Civil society plays a vital role in strengthening public confidence in state institutions, ensuring social stability, and improving tolerance within a free and democratic society. For a civil society to fully exercise this role, it is vital that it is granted the right to form associations. Here in the Maldives, the right to form associations is guaranteed by international law and the Constitution. While Article 30 of the Constitution guarantees the freedom to form associations, societies, and political parties, Article 27 establishes the right to freedom of thought and expression to be exercised in a manner that is not contrary to any tenet of Islam. I'm Zaishan Ahmed, and this is the Fourth Estate. This week, we are going to discuss the Associations Act, which came into force in 2003. To talk with us on the subject, we have with us here Christopher Roberts, a lawyer who worked as an international legal consultant with Cairo Institute for Human Rights Studies in Egypt. He has worked on examining the right to freedom of association in international law and in Egypt as pertaining to civil society, political parties, trade unions, and professional associations. He also works for the International Center for Not-for-Profit Law, providing analysis on freedom of association and assembly in Egypt. He has also worked with human rights organizations in the USA, Tunisia, Lebanon, and India, and with prominent organizations such as UNICEF, Human Rights Watch, UNHCR, and Amnesty International. Christopher, welcome to the show.
Thank you so much for having me.
First of all, let us be clear with these terms. Now, we're talking about freedom of expression, freedom of assembly, freedom of association. What do these terms signify?
So all of these terms are recognized components of international law. They are protected by a number of instruments in international law, but primarily by the International Covenant on Civil and Political Rights. That covenant is one to which the Maldives is a party, and Article 68 of the Constitution also states that one should look to the international treaties to which the Maldives is a party when considering constitutional questions. So in this way, these issues are brought within the Maldivian constitutional framework, and of course they each have their own provisions within the constitution as well. Freedom of expression, freedom of association, and freedom of assembly are what is known as the civil and political rights, but they're also enabling rights. And what that means is that these are the fundamental components of a just society that are necessary in order for citizens to be able to push for other rights. So if it's possible to form an association, then that association can help to provide for the right to food, to water, to health, to education, for a clean environment, and so forth. The right to assembly is a way to ensure that the voice of the public at large can be heard. And of course, the right to freedom of expression has many components. It means access to information, and the Maldives is to be praised for the access to information law it's passed recently. It means that the law should never penalize somebody for exercising their right to freedom of expression. And of course, it's the principle upon which the Fourth Estate and the media is based.
Okay. So are there any links between these terms, freedom of assembly, expression?
There are indeed links between these terms. I mean, it's hard they are in a sense inextricably linked because, for example, if you guarantee the right to freedom of association, if you let people form associations, but you do not guarantee the right to freedom of expression, and you say, well, if your association takes this particular point of view, then that association will be forbidden, then of course the right to freedom of association is essentially meaningless. The same thing, of course, with the right to freedom of assembly. If you carefully control the messages that can be conveyed through those assemblies or the types of speech they might involve, then again, that right is stripped of its meaning. And similarly, the right to association, for example, is an important way to achieve the fulfillment of the right to freedom of expression. So, because most fundamentally, the right to freedom of association simply means that different people can come together, can work together towards a common purpose without seeking a profit by doing so, and being able to work together towards an intended goal is an important part of freedom of expression in any society.
Okay. Now, what is the purpose of an Associations Act?
So this is an excellent question, and I'll spend a little bit of time on this because I think it's very important that we get this right. Unfortunately, historically, I think, and also in many countries of the world, there is a notion of an Associations Act that civil society and associations are something dangerous, something we need to fear, something we need to carefully control and to restrict. The fundamental philosophical shift that needs to be achieved in order to have a positive Associations Act is to change that mindset, to recognize that in fact civil society associations are a vital part of a healthy society, that they work to provide education, to provide cultural possibilities. They might be sports clubs, they might provide healthcare, and so on. So it's fundamentally important that one shift their mindset when thinking about freedom of association and a law on associations from we need to use this to control civil society to asking the questions about how can we in fact enable civil society and allow it to do its job better and to help society as a whole. Now, many people voice concerns when sort of dealing with this shift, and they say, but what about the problematic associations? What about money laundering? What about drugs, potentially a drug gang? What about fraud or something like this? And of course, these are legitimate concerns. But I think there's two fundamental points we need to bear in mind when thinking about these things. The first and the overarching question is an associations law the best way to tackle these concerns? And I think international practice is quite clear that it's not. Basically, each one of these very important legitimate criminal concerns should be covered by its own law. It should set up an authority with expertise on that particular area, and it should place that authority under the power of the prosecutorial services who are familiar with dealing with criminal law matters. Placing that authority, on the contrary, under the framework for governing associations forces that particular governing body to end up with this very broad mandate. They have many different things they're supposed to cover, and they're not able to specialize in the issue in question. And it also means that the vast majority of associations which are concerned with charitable services and the like are suddenly treated as if they're doing something criminal when in fact they're trying to help society. So it's not that these are not legitimate concerns, these are very legitimate concerns, but the best approach from a governance perspective is to separate out the issues within law and to separate them out within terms of the body that ends up dealing with them.
Okay. Now, the Maldives is a fledgling young democracy. How is the Association Act relevant to a country like this? You must have had vast experience working in countries, developing countries. Based on your experience and your information, what would you say about this?
Sure, that's a great question as well. So I think the first point to mention is that as we discussed a little bit earlier, an associations law is a fundamental part of building a culture of human rights. It's also the right to freedom of association is a fundamental part of democracy. It's the ability to work together with the fellow people in your country in order to be able to advance the ends you hope to achieve. So it's very important because without putting these building blocks in place, it will be impossible to arrive at the next steps, to arrive at the other goods you hope to see in society. In addition to this, I think sometimes one thinks that it's necessary to achieve a great level of development or to be able to put endless resources into an issue area in order to be able to see any positive outcome. And there may be some areas where a great level of resources is indeed necessary, but an associations law, one of the wonderful things about getting the legal framework right in this area is that in fact it can be relatively simple, and the most positive law will create a simplified framework which doesn't place much burden on civil society, which similarly places a less burden on the governing authorities. And in this way, it's possible to really unleash the power of civil society and allow them to do good for the country as a whole. So it's really a win for all parties.
Thank you. Now, in your short commentary on the Associations Act, you have pointed out some issues that you have observed regarding the Act. Firstly, you stated that the law must recognize the right to freedom of association as such without the need to register under the law. What is the significance of this?
Yes, this is also quite an important point, and so I think we should think about it in a couple of different ways. First of all, it's important to start from the beginning by recognizing that association is a right. And in international law, every right has essentially three components and three obligations: the duty to respect, the duty to protect, and the duty to fulfill. In the context of associations and the right to association, the duty to respect means that the government should recognize that people have the right to association. This is already something that is inherent in them. It is a right they are free to exercise, and that they will do so without any legal framework in place. They will come together to work towards a common end. This is the duty to respect. The duty to protect means to recognize the negative obligation. Nobody should be forced to join an association which they do not wish to be a part of. And the duty to fulfill corresponds to what should be the purpose of an associations law, which is to pass a law which will in fact provide a number of legal benefits to associations which register under it. Now, when we talk, so first of all, it's important to recognize that the right to exist as an association that is unregistered is a fundamental component of the right. Secondly, I think this simply makes logical sense. In the current law from 2003, an association is defined in part as an association as registered under this law. Then there's an attempt to penalize non-registered associations. But associations are already defined by registration. It's a fundamental component of them. And this is because it's very difficult to come up with a definition of association that without using the framework of a law. So in addition to this, I think the point that people need to understand here is that the right to exist informally does not necessarily mean in all circumstances. So it's perfectly reasonable for the law to state that if an association is operating with a significant amount of money above a certain threshold, if they are paying employees, for instance, if it's basically, if they have governing documents, if it's a large-scale kind of institutionalized formal institution, then it's perfectly reasonable to ask that it be registered under the law. The point of or the core importance of respecting the right to freedom of association outside the law is for small-scale associations, for several individuals coming together, perhaps for a sports club or a chess club, and there's no money involved. They're simply friends who have a common interest, and it's very important that we recognize that, of course, this is something that is a right.
Okay. Now, secondly, you have stated that the law is broad and vague as to the provisions governing the registration and operations of associations. Can you elaborate on this?
Yeah, so this is part of a broader problem, which I think is that the 2003 law currently allows too much discretion. So this there are multiple ways in which a law can grant too much discretion. It can make decisions possible in cases where a decision should not be possible. In the current 2003 law, there are a number of decisions which simply, there are a number of cases where the law simply refers to a discretion on the part of authorities whereas it should state that those decisions will be made in accordance with the law. And there are also a number of other places where the terms within the law are overly broad and vague. And this is something that I think lawyers address all the time. It's quite clear within international law where as an issue where the principle is known as the principle of legality, which means that not only must important issues, and particularly restrictions, be laid out in the law itself, but also that any such restrictions in the law are in very clear and precisely defined terms so that people reading the law know exactly what's expected of them, what they can and can't do. So currently, there are problems around, for example, discretion granted relative to the names or symbols that associations hope to have. So it's broadly recognized in best practice on associations laws that an association cannot take the same name as another association because this will create confusion. People won't know who they're dealing with. In the 2003 law in the Maldives, on the other hand, the registrar is granted what seems to be unlimited discretion around names. So it becomes a matter of do they like the name or not? How do they, rather than something that's clearly laid out in law. Similarly, the law fails to be specific as to the reasons particular provisions within the regulations, the proposed governing regulations of an association can be refused. The law requires prior approval for the acquisition of funding, which is not necessary in international standards, which stipulate that annual reporting, together with audits, if we're dealing with if an association is dealing with large amounts of money, are sufficient to ensure financial regularity. So these are some of the examples of how the law is granting excessive discretion.
Okay. You have also stated in your commentary that the law should assure that an independent and an impartial governance system for associations is in place. Now, how is this a necessary change for this country in particular?
Yes, I mean it's a very important point, and in fact I think it is a component of international best practice. So I would say every country should ensure that the system governing associations is independent and impartial. There are a number of ways to do this. You need to ensure that the process of appointment is one of consensus. You need to ensure that the position is insulated from political interference. It's positive to have a body, in fact, rather than an individual, to ensure that multiple perspectives are included. And you want to ensure that any appointment process is public and that you allow consultation from the public at large as well as from civil society. And this is important because the body responsible for registering and overseeing associations has a lot of power relative to the civil society sector. So if that body becomes political, it will start to use that power to interfere with the operations of civil society. In particular, when you have distribution of some sort of public goods, funds or land or something like this, when there are political authorities and when the law is not clear as to the grounds upon which such goods will be distributed, it's likely that the goods will be distributed to certain civil society groups over others, and indeed this is what what civil society in the Maldives is indicating is often the case.
Now, how can the law be changed to support and encourage the civil society? You have mentioned that there are certain provisions which need amendment that are posing a burden on the civil society because they are not amended. So how can the law be changed to support and encourage the civil society? What should be done?
Sure. So I think essentially all of the changes that come from international best practice taken together form something of a package that will support civil society. But some of the most important ways to do so are first of all, by ensuring that the procedures that they're required to follow are simple, are clear, are regularized, that they're not constantly wondering, that they're not unaware of the sorts of activities that might get them in trouble, and that they are guaranteed the ability to undertake all the sorts of activities that they should be able to undertake in compliance with the right to freedom of association and the right to freedom of expression and so forth. Secondly, I think, and this goes back to the fundamental philosophical point, when civil society is seen as something of a problem, there's a tendency on the part of drafters of a law, and this is true in the Maldives, but in any number of laws in different countries, to attempt to specify with particularity how associations should internally govern themselves, what their internal governance structure should look like. And this is a problem both because fundamentally those are questions for civil society actors themselves, and also because there is no one best model. There are countless different models that can be used to determine civil society governance. So for instance, one civil society may prefer to set up a board of directors which is self-perpetuating, which means that that group will come up with rules for the appointment of new members and it will work that way. Another group may prefer to have votes among its general members. This is what happens usually in an association organized around a particular profession, for example. So instead of seeking to impose one governing structure, which first of all, there is no one right choice, and secondly, actually places a very heavy burden on the authorities, because now suddenly they're a component of the governance of every civil society association, which is an impossible task to ask them to achieve. It's far better if to give freedom to civil society in this regard, and instead to provide some examples of best practices or different possible templates for how you can govern your association. In addition, the Maldives, of course, has a somewhat unique geography, although perhaps a fundamental component of that is that it's difficult to travel, from one region to another, which is true in many countries. It's difficult and it can be costly. Currently, the 2003 law has some stipulations governing the need to hold general assemblies at annual general assemblies and some precise timelines as to when those have to be held. This is often something that's very burdensome for civil society, especially in a country like the Maldives, and especially if they have a representation across several different islands and areas, because of the costs involved and so forth. And so that too should be a matter left to the associations themselves, depending on their particular governance structure. Thank you.
We'll take a short break now. When we return, we will talk more on this issue with Christopher Roberts. Please stay tuned with us.
Neutro Special Crackers est a bike itbar hoda pave.
Varam
Neutro Special Crackers ki packet gagin adada ka biskode kuleve agiya meeru biskode.
Varak kamada biskode.
Binda binda kala Neutro Special Crackers. Lonomed tomato mirhuge avapi dessa.
Miru King garlic chili sauce.
Mirko furihamako kaleveni miso surege.
Miru King tomato sauce.
Kumbeko me sauce kamakunude. Hamarangani.
Miru King chili sauce.
Sauce veggia rahe besunje.
Miru King fried chicken chili sauce. Enjoy the great taste.
King tomato sauce.
Aku ni badal kuliah mujahara kura cara dong. Mide Smith juga warab bogina. Ego tum party bodong. Mr. Ibure, adi Smith na midani botang among gina ngomong. Miaru mia. Salamat di kata taka behe fulong. Misal dang eba. Anna yang alora hiwani kino yagi inge to hama warak carry je. Mihar. Eu fry inge to alora inge. Isbe fulong eu fry ni. Eu fry inge to. Eu fry. Ibure bo mating inge inge to. Nasibo ko alora saja syukuria.
Fad hardware veliga.
Tom Garden, imported and marketed by Miami Traders, phone 331 8850
හුසේන කීගත කියනි
මී කියන රෙඩුවේ ප්ලාසා මෙයා නොදෙවිච්ච ෆාහොන් තෙරවංජේ
එයෝනෙක්ක
අස්ත මෙයා රෙඩි එම්ම ෆවගේ මොබයිල් ෆෝන ලැප්ටොප් ඩිජිටල් කැමරාය එම්ම ෆවගේ ටීවී එක සයිස් ක්වලිටි ප්‍රොජෙක්ටර් හાર્ඩ් ඩිස්ක් LG බ්‍රෑන්ඩ් ගේ එනර්ජි සේවින් දොන්න මැෂින් ෆ්‍රිජ් ආදෙච්ච
මලෙට්වේ ප්ලාසාග
ඒර එම්ම ෆවගේ මොබයිල් ෆෝන ටීවී ලැප්ටොප් සෙහෙරි ගෑග්ගනක කිලේ
හිලයි
එයා හෙවීම දෙම්බුණානි හිලේ
ඕ ගද රෙඩ්වේව් මොන් දෙටිති ගෙන මති එම්මනවෙස් ගනව
රෙඩ්වේව් ප්ලාසා
Welcome back. You've commented in your commentary that if all of these issues are addressed, the Maldives may achieve a simplified and streamlined legal framework for civil society. How would this benefit the government?
I think this would benefit the government in a broad number of ways. First of all, obviously it will improve the situation for civil society, who will now know precisely what is expected of them. They will have less burden in order to fulfill the relevant paperwork. And of course, if civil society benefits, then society as a whole benefits, because the various goods that civil society is designed to provide may be more thoroughly, more fully provided. And if the government passes a positive law, and then civil society provides goods to society, both civil society and society as a whole will recognize that this law is a positive achievement, and so that is something to the government's credit. In addition, simplifying and streamlining the procedures is to the benefit of the authority tasked with overseeing the law, because when they have a very large amount of discretion, when they have a very broad mandate, when they are given all of these tasks, such as we have been discussing, relative, for example, to the internal governance of associations, or having to look over every small article of those associations' governing documents, they're given this massive potential task. Moreover, as we were discussing before as well, separating out the issues of criminal law concern, or the issues of serious potential violation, helps each component part of the government to develop a specialty in a particular area, and helps devote resources to precisely where they're needed. So even for those concerned with addressing those problems, I think removing them from the context of the associations law and placing them into a different framework, and taking the extra resources and manpower and hours and attention and putting them into those specialized agencies will help achieve the ends and will help improve governance.
How would this benefit the civil society and the general society at large?
Yeah, I mean, so in discussions with civil society in the Maldives, I was very fortunate to be invited here by Transparency Maldives, and yesterday we had a symposium, which was excellent, and that brought in a large number of civil society participants, and we discussed legal standards, and also several, the positive work that they do, as well as several of the issues that they're facing. And I think they are all to be commended for the sophistication with which they've grappled and with these legal issues, and the clarity with which they're presenting the problems that they're facing. And one of the most significant problems is simply the confusion, for example, over what exactly is required of them. In terms of the 2003 law, currently within the law itself, over a dozen different sorts of information have to be provided to the government should the association seek to obtain legal status. Different sorts of association, different sorts of information, each one of which is potentially quite complex. But in addition, under the currently existing framework, numerous other pieces of information have to be submitted as required by regulations. So not only do those regulations then add to the responsibilities of associations, but they're contained in a different place and they're not as publicly visible. So it makes it quite difficult for associations to know exactly, to get all of their documents in order. Of course, governing regulations are one component, but I think they're an important example of the system currently in place as a whole that does not provide civil society with the ideal clarity as to what exactly it has to do. And as we already emphasized, I think ensuring the independence of the bodies governing civil society is also very important in order to ensure that the bodies with whom civil society has to interact are as appropriately suited for their tasks as possible.
Okay. Now, corruption is a growing issue even in the Maldives, and also many developing countries face this issue. Now, you've outlined the need for a simplified and streamlined legal framework of civil society. Now, how would such a framework address corruption in this country?
Certainly. So, I think this goes back to one of the core issues of concern. On the one hand, as we've noted, certain sorts of criminal corruption should be governed by a particular law specifically devoted to that, and by prosecutorial authorities. I know from my own work as a lawyer, having to adjust these things on a legal level is often quite complicated, and it's very important in order to respect the various criminal procedures and so forth involved, that you put such investigations into the hands of professionals so as not to end up with tainted evidence or other procedural issues down the line. So this is the more serious forms of criminal corruption. Relative to associations, you have a couple different mechanisms. First of all, the associations have an annual report in which they note their sources of funding and also the activities they've engaged in over the course of the year. And secondly, for associations of a certain size, meaning associations which take in a certain amount of income, you can put an auditing procedure in place, or alternatively, or possibly some combination of these two, you can utilize audits when there are reports of issues of corruption. And international practice has shown that these mechanisms together are sufficient to ensure that there are no serious to address financial irregularities within the sector.
Thank you. So you've highlighted that the current Associations Act needs a lot of amendments. To what extent does the current Associations Act of 2003 reflect international best practices?
Yeah, so I think the first issue that's important here is that we recognize that there are both international obligations and international best practices. So unfortunately, the 2003 Act is not good on either account. So certain issues coming from international law, for instance, the right to freedom of association means that unregistered associations have to be recognized to a certain extent, as we've discussed already. So it's important to recognize that some of these recommendations, in fact, are obligations under international law to which the Maldives is a party. Other things, more to do with perhaps how best to ensure the technical procedure of registering associations, for example, potentially allowing an online procedure that might be quite useful in the Maldives. Such a procedure has been implemented in Japan, for example, are more about international best practices. These are things that international law doesn't require, but that are very positive. Now, the 2003 law of the Maldives unfortunately has a number of problems in both regards, I think, as we've already been discussing. And so I think, so we can speak about the problems relative to the framework for obtaining legal status, the purposes of associations within the limitations on the purposes of associations within the law, the manners in which dissolution might be imposed, as well as general principles of good governance, to name a few issue areas that should be changed within the law. But I think, again, the most important message here and the most important thing is to change the underlying philosophy with which you think about an associations law, to move from that repressive or restrictive, controlling philosophy to an idea that we're using this law to enable and to empower civil society. And once there's a change in mindset of that manner, then I'm sure that the law that will be drafted following such a mindset will comply with international standards.
Okay. So you've said that the current Associations Act does not reflect international best practices on a large scale. Why do you think there are so many potholes in this act? Why do you think there's so much room, so much space for amendments?
Yeah, I mean, first of all, again, it goes back to the issue of the underlying idea with which the act was drafted. In addition, I think some issues of, in addition within the context of the Maldives, I think the act was simply drafted before the 2008 constitution, and once the mindset and the philosophy of the current constitution of the Maldives can be used to draft a new act, that will very much help along the same lines. In addition to these points, I think simply actually looking to international standards, which in fact are quite detailed on a number of different issue areas. There are, I mean, any one area that we're discussing today, for example, how to ensure independence of a governing body, or issues around providing public support, for instance, and how you ensure impartiality, non-discrimination through the provision of such support, is laid out in quite significant detail within international legal standards. So once you look to those texts, you're able to provide a lot more detail to allow the system to operate according to the law, to create a law that people can come and can read and can look at and can understand exactly what they have to do and what the obligations on them are. I think another, a very related issue with the current legal framework is that because the 2003 law simply does not spell out a lot of potential detail, those matters have been dealt with by regulation. Now, international standards suggest that you should never impose restrictions by way of regulation, because regulations don't go through the same sort of democratic process as legislation. Then the public is not as aware of them, and the public is not as easily able to access them, to become aware of them. So I think it's important to spend some time on the law itself to really get the text right and to ensure that all of the international standards are respected, and that regulations then simply help to further clarify, to further develop the framework that's already set out in the law, rather than trying to fill gaps and creating additional problems.
Now, you have pointed out in your commentary that Article 6b of the Associations Act prevents children from founding associations in violation of the Article 15 of the Convention on the Rights of the Child. Now, what would be the implications of the law preventing children from founding associations for a country like this, with a population that is mainly of youth and children?
Sure. As you say, it's a very important issue. The right to freedom of association is contained within the Convention on the Rights of the Child. The essential structure of that convention notes that children should be accorded such rights in accordance with their developing capacities. And again, I think this changes, your approach to this changes as soon as you change your fundamental philosophy. Once you see that if you're worried about civil society, you think, oh no, we need to keep kids away from associating with one another or taking part in a group. But if you see civil society as a means to educate, for example, when I was in high school, I used to, when I was 17, for example, I would go to the elementary school and teach math after school or teach chess after school. As part of a group of students. And there are provisions for students' groups within the current, within the 2003 law, but other forms of groups that children might wish to found towards such positive purposes, towards playing a sport together, towards playing a musical instrument, a theater group, and so on. Of course, they should have the freedom to do these things, and it encourages them to be a positive and an active part of society down the line. So I think we need to recognize that civil society is a good thing, and that it's very positive that youth and children being defined as people under 18 years of age, are able to form associations and to pursue their interests and to work for the benefit of their fellow country people.
Do you believe that the government should encourage children to found associations?
I mean, it's an interesting question. Of course, associations are positive, but it's important that we also recognize the independence of the space of civil society. So the first step is to recognize that children, like all other people, are free to form the associations that they wish to form. In addition to that, I think once that the sphere and the independence of civil society is established, I think it is very positive for the government to encourage the formation of associations by children and by adults. And we haven't discussed this already, but another fundamental component of thinking about the legal framework in an associations law as a positive one is providing certain incentives to the foundation of associations. So an association under the law should have legal status, it should have the possibility of owning property, it should have the limited liability for its founding or executive members, it should have certain tax exemptions, and it should be able to and possibly, if resources allow, it should even receive some forms of state support, provided that those forms of support can be provided in an equal, non-discriminatory way that is clearly laid out by law and doesn't infringe the independence of civil society.
We'll return after a short break. Please stay tuned with us.
Baby, like Anika was savage. 1, 2, 3, 4 piece free. We wouldn't baby like it. But 12 case, 1 case free. Tutu therefore go for la hingama jehuma. Baby like pena korama.
Minute, data, SMS, and the IDD discount apply for our postpaid smart plan.
Here at ProLab Computers, we make sure that our laptops are sold with the factory configuration with no other changes. With many shops around, you never know what you're buying because an original operating system and a fake OS just aren't the same. On top of that, ProLab offers a full local and international warranty. Any problems, just walk in. We're here to help. Call us at 796-10100 or visit us at www.prolab.mv.
Hello, Jelly Italian pizza.
For no, but in pizza. Tafata Ramir Jelly Italian pizza. Coke Oreo Shagna the Joe boy, Gang was the numbering killer. Or the Kuravama, Kinet Summing a shit, not the Nuen for head, Nuen, I'm a Bulova. Jelly Italian pizza. Every little bite counts.
බොඩුරාලු ගෙනෆෙන් බිස්නෙස් ನೀಗಲೋಟಿ ಸ್ಟೇ ಫ್ರೀ ಸೆಕ್ಯೂರ್ ಡ್ರೈವರ್ ಫೇದಿಗೆನ್ ದಿಮುಗೆ ಬಾ ಅಶಾಲ ಗುಣ ಇತುರ ಕಂಟ್ರೋಲ್ ಕೊದ್ದೆ ಬ್ಯಾಕ ಹಿಮೆನಿ ಫವಾತಿ ಅದಿ ಫನ್ಸಾಸ್ ಗುಣ ಅವಹಂ ಹಿಕಿ ಕಿತಂದಗಿನ ನಯಸ್ ಹಿಫೆಕ್ಟ್ ಮುಗೆ ಬಾ ಎಕ್ಕಂ ಕಂಟ್ರೋಲ್ ಕೊದ್ದೆ ಎಮ್ಮಿ ರಕ್ಕಾ ತೆರಕಂ ಬೋಡಿ ಸ್ಟೇ ಫ್ರೀ ಸೆಕ್ಯೂರ್ ಡ್ರೈವ್
Effect, the mental energizer. No effect without effect.
Aharin coast milk boni kivekam bonadanta sabavaki emiunge geritaka kanden haddamene tabbarattasa adi e hafi geritaku ekaneki mi vinata mihem vegen geritakuge sehatu e harangari ehen kamu mi geritaku libe kiruani hashigada fada hori eta madda takakum musadyo mi coast kiruga taza kamuge sirani mi sababattaka anna emme kamudani coast kiru
Welcome back. Now, the right to found associations should also not be limited to nationals, because in a country like this, we have so many immigrants, and this is the case with many other countries of the world. So what is the significance of this? Why should non-nationals be allowed to found associations as well?
Yes, this is a very important point. International standards are quite clear that non-nationals are also able to form associations, and this is in part because we recognize association, as we recognize all human rights, as human rights. They belong to all people, wherever they are. So it's important that simply because you're outside the boundaries of your country, you shouldn't be prevented from associating with other people, from pursuing a common purpose, from forming an association to advance the issues that you're interested in. Of course, this is an obligation coming from international law, and I think it's important, and I think it's useful to perform the exercise of putting yourself in both positions in this sort of situation. If you were living overseas, do you hope to have your rights in that other country? Do you think that simply because you're visiting another country, you come from the Maldives and you're visiting another country, should you therefore lose your right to freedom of expression and your right to freedom of association? I think everyone recognizes that their rights should belong to them wherever they might choose to go, and the right to freedom of association is a fundamentally important one. And hence, recognizing that right granting that right to non-nationals is also very important. In fact, in the current 2003 law, the law itself does not deny this right, but it's another example where regulations have stepped in to impose an additional restriction because you're required to show Maldivian ID cards in order to found an association. So I think that's certainly something that should be amended.
For example, if we allow non-nationals to found associations in our country, how would it benefit the civil society? How would it benefit the society at large?
So first of all, I think the core issue is that civil society associations are designed to fulfill purposes which benefit the population. So let's say there was a perceived need for educational programs. The educational programs run by a civil society organization would help to support and alleviate some of the burden placed on the education systems. They would help to achieve a populace that's more aware of rights and more aware of the importance of society and of living together. And I think, of course, any purpose like this can be achieved by an association set up by a Maldivian NGO or set up by an NGO founded by people of Maldivian nationality or founded by people from another country who are living in the Maldives. I'm sure that many great NGOs in the world, in countries that allow for civil society to be founded by non-nationals, are in fact founded by non-nationals. You don't even think about it because it's serving society as a whole, and that's what's important.
Now, you have had vast experience working in various parts of the world on issues concerning right to freedom, right to assembling, and also right to expression. Now, how do you compare the status of these rights in Maldives to the rest of the world, based on what you have seen and learned so far?
Certainly. So I'll speak about my recent experiences. I've been living and working in Egypt, but I've also been working on issues in several countries in North Africa. So in Egypt, I was assisting efforts for several years to attempt to achieve a new associations law and a new framework around freedom of association. I think there was at one point in that process some positive progress. We started to see the thinking begin to shift from the idea that an associations law is intended to control civil society to the idea that it's supposed to enable civil society. But unfortunately, events in Egypt and the recent political situation has been very much moving in the other direction. The government, relative to freedom of association or freedom of assembly and freedom of expression, to name just a few, has clearly been moving to limit and deny these rights as much as possible. In Tunisia, on the other hand, I think things have been very positive. Following the revolution, the Tunisian state was able to pass positive legal frameworks relative to freedom of association, relative to access to information, relative to freedom of assembly, as well as addressing other areas related to freedom of expression. And this has really created a space in society that where civil society has gone from almost non-existent to incredibly flourishing, and it's really it's really helped to create something special, I think, in Tunisia at the moment. I think the situation in the Maldives is nothing like the situation in Egypt. I think some of the examples of Tunisia are very positive, and I believe it's entirely possible to sit down together to think, in a rational way through the various issues, to listen to the concerns of other people and to find ways of dealing with them. For example, through taking the legality concerns very seriously, but addressing them with separate bills, for example. And I really think there is the possibility in the Maldives to pass a very positive associations law that will serve as an example. I mean, some of the certainly in some countries that have a lot of resources, they're able to provide large amounts of public support or something like this. But as I stated before, there is no need in the context of an associations law to necessarily be able to bring a lot of resources to bear. If you can just create an enabling framework, the law will allow civil society to flourish. And so this has been seen in Tunisia, Armenia, Romania, other examples of countries that have very strong civil society laws. So I think it's very achievable, and it will just simply require the parties coming together and working together towards a positive text.
Okay. Now we'll move the discussion towards the media, because the media is a considerable and dynamic force in this country. Now, what role does the press or the media play in ensuring that the Associations Act is fully implemented?
That's a great question. I think the first important role the media can play is not to engage in flattery, but I think actually hosting discussions which look in depth at the various issues involved in this area are very important. sharing those perspectives, allowing people to understand the different components of the law, the different fundamental ideas, and make their own opinions. Secondly, I think it's important to actually speak to civil society actors. Too often, I think some of the best members of our societies, they work long and hard to educate children after school hours, or to provide healthcare, or to clean up garbage or something like this, and those efforts go unseen and unheard and unrecognized. So I think recognizing the positive contributions of civil society and the positive role civil society plays is also very important. Third, I think along with that, investigating the situation in which civil society finds itself, speaking to civil society actors, discovering the problems that they're facing is another very important role in order to be able to publicize those issues and ensure that those are included in the public debate.
Okay. Now, you've mentioned about the underlying philosophy that needs to go from being repressive and regressive to more liberal and progressive. Now, how can the media encourage such a philosophy to gain foothold?
I think first of all, it's important to reiterate this message and to really drive home the importance of changing the underlying philosophy. I think in addition to that, focusing on another way to think about this is simply to focus on human rights and to start asking the question first of what are the rights at stake here, and what does it mean to be a right? What does the right entail? To think from the perspective of individuals possess rights. And so that the first question of any piece of legislation should be, how are we helping to advance those rights, to fulfill those rights on the part of the population? And I think if the media itself also focuses on simply, as we already discussed, relative to freedom of association, but also, for example, issues of freedom of expression, any area where it seems that the right is being stifled or limited, and if that becomes a guiding principle in terms of how the stories that are focused on are determined, I think then the media will really be playing a very positive role in helping to ensure all of those rights.
Now, amending a law surely demands cooperation from lawmakers, the government, and the civil society. And in the case of the Associations Act, you have mentioned so many places where amendments can be brought. Now, what would be the general outcome of bringing such amendments to our country? Because we are trying to push ourselves from the status of being a least developed country, or let's say a middle-income developing country, to being in the first world. To being a fully developed country. So, how would it be, for us, if the outcome of such amendments?
Sure. So I've had the opportunity and the honor while I've been here to meet with representatives of various civil society groups, to meet with the Attorney General and members of the relevant parliamentary committee, and I was struck by the thought they've all put into this issue. I think there's a broad recognition that the current legal framework needs to change, and the desire to work together to produce a legal framework which will ensure a better outcome for civil society, for the government, and for the Maldives as a whole. I think civil society plays a fundamentally important role in helping a country to move forwards. It serves to provide any number of benefits to the population. It serves as a means to identify problems or issues that might otherwise go unidentified. It serves as a means to highlight best practice and to suggest inputs as to changes in policy that may produce a more effective governance system. And in addition, I think finding the right framework around this law will also help the government itself to focus on areas of serious concern and allow civil society to thrive and to help play its role in moving the Maldives forward. If the media is a fourth estate, we could say that civil society is a fifth estate.
Sorry to cut you short, but that's all the time we have for now. Thank you for joining, Christopher. This is me, Jashan Ahmed, signing off, hoping to return next week to discuss another issue of national and social importance. Thank you for joining us this evening.